The Agricultural Land Reform Code, Republic Act Number 3844.
The Agricultural Land Reform Code was enacted under President Diosdado Macapagal. This law aimed to provide and distribute farmland and landless tenants, and abolish tenancy or kasama system, and build or establish a landhold system. Also, this law created the Presidential Land Committee, including the Land Bank of the Philippines, that would assist in the purchase of agricultural estates for division and resale to small landholders, and the purchase of land by agricultural lessee. Lastly, they limit land ownership to 75 hectares. Salient features of Agricultural Land Reform Code. Here are the main features. First, it replaced the shared tenancy system with a leasehold system. Second, it declared the rights of agricultural laborers. Third, it gave authority for the government to acquire and distribute agricultural lands. It also created the land bank to finance land purchases and provided machinery for marketing and credit assistance. The law promoted unified administration of land reform, expanded land service and classifications, and set up a judicial system to handle land issues. Abolition of agricultural shared tenancy. The law declared that the agricultural shared tenancy system was contrary to public policy. This means that it was considered unfair and exploitative, so it was abolished. However, the abolition was done under specific conditions and exemptions provided in the code. Establish of agricultural leasehold relation. Under this law, the agricultural leasehold relation can be created by law or by agreement, either oral or written. This relation is based on Section 4 of the Code, and it officially recognizes the relationship between a landholder and a cultivator or farmer. Parties to agricultural leasehold relation. The agricultural leasehold relation involves only two parties or shall limited to. First is the landholder, who may be the owner, lessee, or legal possessor of the land. Second, the person who actually cultivates the land, meaning the one who personally tills and manages. Tenure of agricultural leasehold relation. Once the leasehold relation is established, the farmer or lessee has the right to continue working on the land. This right continues unless the leasehold relation is lawfully ended. The lessee also has security of tenure, meaning they cannot be removed or ejected from the land unless authorized by the court. How agricultural leasehold relation is extinguished. The agricultural leasehold relation may end only under certain conditions. First, if the land is abandoned without the landowner's knowledge. Second, if the lessee voluntarily surrenders the land, but with written notice at least 3 months in advance. And third, if there is no person to succeed the lessee in case of death or permanent incapacity. Death or incapacity of the parties. Lastly, the leasehold relation does not end automatically when either party dies or becomes incapacitated. If the lessee dies, the landowner may choose another qualified person who can continue cultivating the land. This decision must be made within 1 month after the death or incapacity occurs.
So let's talk about the lessee's right of preemption. This simply means that if the owner or lessor decides to sell the land, the lease has the first opportunity to buy it. The terms shall be reasonable, and the lease must be given written notice about the sale. From the date of that notice, the lease has 90 days to decide whether to buy the land, and if there are several leases on the same property, each one can only buy the portion they actually cultivate. This right protects the lease from losing the land they've been working hard on. Next, we have the lessee's right of redemption. Now, this comes into play if the land is sold without the lessee's knowledge. Even if the sale already happened, the lessee still has the right to redeem or buy back the land from the new owner under the same conditions. So this right must be used within 2 years from the registration of the sale. Among all redemption rights, the lessee's right is given priority, meaning they come first before others. This ensures fairness and protection. Moving on, let's discuss the agricultural leasehold contract in general. The lessor and lease can agree on any terms they like, as long as these are not against the law, morals, or public policy. However, the contract becomes invalid if it includes unfair conditions, such as rental fees that exceed legal limits. If the lease pays more than the fair value for animals or equipment, if the lease is forced to do unpaid work or pay fines, or if they are forced to take loans or pay in kind instead of money. These rules are meant to protect the lease from exploitation. Now, about the form registration of the contract. For the contract to be valid, it must be in writing and in a language that the lease understands. It should be signed before a justice of the peace and witnesses by two people. There must be 4 copies, one each of the lease and the lessor, the municipal treasurer, and the agrarian council office. No fees or stamps are required, and the contract becomes binding 30 days after registration, unless someone contests it. So this process ensures that the contract is official and transparent. Next is the registration of leasehold contracts. So the municipal treasurer is responsible for registering these contracts and keeping records of them in the registry of agricultural leasehold contracts. So just like before, no fees or stamps are needed. These steps helps ensure that all contracts are properly documented and can be easily verified. So let's go to the exemption from lien or execution. This means that certain parts of the leased property cannot be taken away even if they have debts. Especially, 25% of the total produce from the farm is exempt. Also, work animals and farm tools worth up to 1,000 are protected, unless they were pledged as collateral. This law helps the lease keep the basic things needed to continue farming and earning. Now, we have the right to be indemnified for labor. If the lease leaves the land for a valid reason or is removed for just cause, they shall be reimbursed from their labor and improvements they made. If they made useful improvements, for example, planted trees or improved irrigation that still have value, they shall be paid for half of their cost. This ensures that the lease hard works and investment are fairly compensated.
Obligations of the lessee. The farmer must properly cultivate the land and perform all work as a good father of a family. So, the farmer has the responsibility to take good care of the land as if it were his own. Dapat niyang alagaan ang mga kagamitan, animals, at siguraduhing tama ang paraan ng pagsasaka. He must also report any problems to the landlord and pay the rent on time. So, for example, if the farmer notices that someone is destroying the crops, he should immediately inform the landlord. And if he accidentally breaks a plow, he must repair or pay for it. Prohibitions to agricultural lessee. It is unlawful for the farmer to contract to work on additional land holdings or acquire and personally cultivate an economic family-sized farm other than their own without the knowledge and consent of the agricultural lessor. So, the farmer is not allowed to work on another farm or rent another piece of land without informing and getting permission from the landlord. Dapat transparent siya sa lahat na ginagawa niya related to farming. For example, ako ay may sariling inuupahan na lupain. So, I cannot secretly work on another farm for extra income unless the landlord allows it. Termination of leasehold by agricultural lessee. The farmer can end the lease during the agricultural year for any of 5 causes. Number 1, cruel or offensive treatment by the landlord. Number 2, the landlord's non-compliance with their obligations. Number 3, compulsion by the landlord to work without compensation. Number 4, Commission of a crime by landlord against the farmer or family. Number 5. Voluntary surrender due to circumstances more advantageous to the farmer and their family. So, the farmer has the right to end the lease agreement if the landlord mistreats him, violates the contract, forces him to work without pay, commits a crime against him, or if it's better for his family to move. For example, if the landlord disrespects, harms, or abuses the farmer, may karapatan or he has the right to terminate the lease and leave the land. Rights of the agricultural lessor. The landlord has the right to: number 1, inspect the farm for contract compliance. Number 2, propose a change in crop or land use. Number 3, require the farmer to adopt improved farming practices considering the farmer's financial capacity and credit facilities. So, rights of the agricultural lessor, the landlord. The landlord has the right to check if the farmer is following the agreement, to recommend better farming practices, and to suggest changes in crops that the farmer can afford. For example dito is, for instance, the landlord may visit the farm to see if it's well maintained and suggest planting vegetables instead of rice if it would be more profitable. Obligations of the agricultural lessor. The landlord must keep the farmer in peaceful possession and cultivation of the land and maintain intact permanent useful improvements existing on the land holding, such as the irrigation and drainage system. So, the landlord must let the farmer work peacefully on the land and maintain the important farming structures like the irrigation or drainage system. Dapat niyang i-ensure na maayos ang kondisyon ng mga ito. For example, if the irrigation system is broken, the landlord or yung may-ari should repair it so the farmer can still water the crops properly. Prohibitions to the agricultural lessor. It is unlawful for the landlord to: first, disposes the farmer except by court authorization. Second, require the farmer to pay taxes on the land. Third, require the farmer to assume the landlord's debt or rent to third parties. Fourth, deal with mellers or processors before rent is paid without the farmer's written authorization. Fifth, discourage or interfere with the formation of the farmer unions. So, the landlord cannot remove the farmer without a court order, make him pay for the land taxes, or stop him from joining any farmers organization. Bawal din siyang manghimasok ng walang sapat na dahilan. For example, hindi pwedeng sabihin ng landlord na bawal kang sumali sa farmers group dahil karapatan iyon ng farmer. So, walang karapatan dyan ang lessor or the landlord. Rights for agricultural labor. These are the rights given to farm workers to make sure they are treated fairly and given proper working conditions. It will protect the farmers or workers against sa pangabuso or unfair treatment. First, right to self-organization. They can form or join a farmers union. Second, right to concerted activities. Pwede silang magprotesta o humiling ng better working conditions. Third, right to minimum wage. They have the right na dapat silang bayaran ng tama at legal. Right to work not more than 8 hours. Hindi sila pwedeng pilitin na magtrabaho ng sobra. fifth, right to claim damages. Like kung may maaksidente man o mamatay sa trabaho, dapat may tulong o kabayaran ang pamilya ng namatay. Sixth, right against suspension or layoff. Hindi pwedeng tanggalin ng walang valid reason ang isang trabahante or worker. Cost of irrigation system. The cost of construction of a permanent irrigation system, including distributary canals, is borne exclusively by the agricultural lessor. So, the landlord is responsible for paying the construction or repair of any permanent irrigation system sa isang farm. Hindi ito dapat ipasa sa farmer. So, for example, if a new water canal needs to be built for the crops, the landlord siya dapat yung mag-shoulder ng lahat ng gastos, hindi yung farmer.
Next is manner, time, and place of rental payment. The consideration for the lease of the land shall be paid in an amount certain in money or in produce or both payable at the place agreed upon by the parties immediately after threshing or processing. If the consideration is in kind or within a reasonable time thereafter if not in kind. This means that rent can be paid in money, produce, or both at the place agreed upon by both parties. Payment is due after threshing or processing for produce or within a reasonable time for money payments. Therefore, an agricultural lessor cannot require an agricultural leasee to file a bond, make a deposit, or pay rent in advance. The second one is exemption from leasehold of other kinds of lands. In the case of fish ponds, salt beds, and lands principally planted to citrus, coconuts, cacao, coffee, durian, and other similar permanent trees, at the time of the approval of this code, the consideration as well as the tenancy system prevailing shall be governed by the provisions of Republic Act number 1199 as amended. The primary purpose of this Republic Act number 1199, also known as the Agricultural Tenancy Act of the Philippines, was to govern the relationship between landholders and tenants on agricultural lands. The third one is possession of land holding exceptions. This means that an agricultural lessee generally retains possession of their land holding. This possession can occur if a final court judgment authorizes it. This is allowed if the lessor owner or their family intends to personally cultivate the land or convert it for non-agricultural use, such as residential, factory, or hospital. In such cases, the agricultural lessee is entitled to compensation equivalent to 5 years' rent, unless the land owned and leased by the lessor is 5 hectares or less. Also, the lessee did not substantially comply with the contract terms or a code's provisions, except in cases of a fortuitous event or force majeure, and the lessee planted different crops or used the land for a purpose not previously agreed upon. The last one, the lease did not adopt proven farm practices as specified in paragraph 3 of section 29. The fifth one means the lessee is at fault for substantial damage or deterioration of the land or permanent improvements. The sixth one means the lessee fails to pay the lease rental when due. However, non-payment due to at least 75% crop failure from a fortuitous event is not a ground for disposition, though the debt remains. The seventh one means the lessee employs a sub-lessee in violation of the terms of paragraph 2 of section 27. The fourth one is right to self-organization. This means the farm worker shall have the right to self-organization and to form, join, or assist farm workers organizations of their own choosing for the purpose of collective bargaining through representatives of their own choosing, provided that this right shall be exercised in a manner as will not unduly interfere with normal farm operations. Individuals employed as supervisors shall not be eligible for membership in farm workers' organizations under their supervision but may form separate organizations of their own. One of the examples of right to self-organization are a group of farm workers at a plantation decides to form a union to negotiate better wages and working conditions with their employer. The employer cannot prevent them from forming this union. However, the workers must ensure that their activities to form the union do not disrupt the normal daily operations of the farm. The fifth one is right to engage in concerted activities. This means that farm workers can participate in concerted activities for the purpose of collective bargaining and other mutual aid. Employers must allow farm workers, organizers, and others freedom to enter and leave the farm where workers live. One of the examples of right to engage in concerted activities is the farm workers at a large plantation. Through their newly formed organization, they decided to hold a peaceful rally during their off hours to protest poor working conditions and demand higher pay. They also invite a labor organizer and legal advisor to speak with them. Under the law, the farm employer must allow the workers, the labor leaders, and advisors to enter and leave the farm compound where the workers live without interference. The sixth one is right to minimum wage. Notwithstanding any provision of law or contract to the contrary, farm workers in farm enterprises shall be entitled to at least 3.50 pesos a day for 8 hours work, provided that this wage may however be increased by the minimum wage board as provided for in Republic Act number 602. So this means that the farm owner cannot pay them less than 3.50 pesos according to the Republic Act number 602, also known as the minimum wage law of the Philippines. The seventh one is right to 8 hours work. This means that farm workers cannot be required to work more than 8 hours a day. Time during which a worker is not working and can rest is not counted towards the 8 hours. Overtime work is permitted in emergencies, and workers must be compensated at a rate of the regular wage plus at least 25% additional pay. Employers cannot compel workers to work on Sundays and legal holidays, but if a worker agrees to work, they must be paid an additional sum of at least 25% of their daily wage. The eighth one is right of actions for damages. Notwithstanding the provisions of existing laws to the Contrary Act of 1874, as amended, entitled an act to extend and regulate the responsibility of employers for personal injuries and death suffered by their employees while at work shall apply to farm workers insofar as it may be applicable. For example, a farm worker is seriously injured due to malfunctioning piece of farm equipment that the farm manager knew was defective but failed to repair. Under Republic Act number 1874 as amended, the farm worker has the right to take legal action against the employer to seek damages for their personal injuries. This claim could cover medical expenses, lost wages, and other compensation resulting from the employer's negligence.
Right to compensation for personal injuries, death, or illness. Farm workers are entitled to compensation for personal injuries, death, or illness contracted while performing their duties. So, um, This simply means that if a farm worker gets injured, sick, or dies while working, he or his family will receive a financial compensation. It's like an insurance that protects workers who risk their health doing their jobs. Based on Act number 3428 as amended, which ensures fair compensation for affected workers, it makes sure that workers are taken care of if something bad happens while doing their jobs. So next we have the right against suspension or layoff. Under this law, landowners or farm employers cannot just remove or suspend workers without a valid reason. This is especially true when workers have already filed a complaint or when there's a dispute being handled by the Department of Labor. If it's proven that a worker was unfairly suspended or fired, um, the court can order the reinstatement and require the employer to pay the wages that the worker lost. Um, this helps to protect workers from unfair treatment or sudden loss of livelihood. So now let's talk about the distribution of agricultural lands. So I'll just explain. So this means that when a public cultural agricultural lands are made available, they are first surveyed and titled by the government. Then it should be turned over to the land bank. The land bank job is to divide these large lands into smaller lots and distribute them to farmers who qualify as beneficiaries. This aims to give farmers the chance to own or manage the land they actually work on. It promotes fairness and reducing poverty among the workers. So let's now define the meaning of agricultural land. So, agricultural land refers to any land used for farming or raising crops. It's not limited to rice or corn fields. It can also include fish ponds, salt beds, or even abandoned lands that can be still used for planting. Basically, as long as the land is used for growing something, it's considered as agricultural land. So let's go to agricultural say and lessor. In farming, there are two important roles, the lessee and the lessor. Agricultural lessee is the farmer who cultivates the land. He's the owner, or I mean, he's the one doing the work or planting the producing crops. Meanwhile, the agricultural lessor is the landowner or the person who allows the lessee to use his land, usually in exchange for rent or a share of the harvest. This relationship between the lessee and the lessor is what keeps agricultural production running smoothly. So, agricultural year. Agricultural year is the period needed to grow and invest or harvest a specific crop. It starts from the preparation of the land to planting, harvesting, and even threshing. For crops that have multiple harvests, the agricultural year is counted from one harvest to the next. This period can be shorter or longer than a regular year depending on the crop being grown. So penal provisions, violations, and penalties. These are the laws that should be followed. But to make sure that these laws are followed, there are penalties for violations. If landowners or employers break the rules, like dismissing workers without cause or forcing them into unfair contracts, they can face fines and even imprisonment. The fines can range from 100 pesos to as much as 500 pesos, and imprisonment can last up to 1 year. Even corporations can be held responsible, especially the managers who oversee the farm operations. This ensures that everyone follows the law and respect the right of the farmers. So flaws of the Agricultural Tenancy Act. However, this law also had some flaws. As you can see, one major problem was the lack of funds. Congress, which was made up mostly of landowners, didn't fully support or finance the program. But because of that, it was only implemented in a few provinces and benefited only a small number of farmers. Another issue was that the law only applied to rice and corn lands. This means that landowners could easily avoid it by switching to other crops like sugarcane or coconut. Lastly, there were no strict penalties for landowners who tried to escape the law by changing how the land was used for transferring it to their relatives. So, to sum it up, the Agricultural Land Reform Code was created to protect the farmers' rights and promote equal land ownership. It gave workers the right to compensation, job security, and fair treatment. But despite its good goals, it wasn't perfect. It had loopholes and lacked full support from the government. Still, this law became an important foundation for future land reform programs that aim to improve the lives of Filipino farmers. And that ends our discussion about the Agricultural Land Reform Code. Thank you for listening, and I hope you learned something about how this law helped shape land reform in the Philippines.